What do co-owners need to know about partition lawsuits in Texas? Co-ownership can begin with the best of intentions, whether it's a shared investment, an inherited family home, or jointly purchased land. But over time, a shared asset can become a source of disputes. In some cases, partition lawsuits help settle these disputes. A partition lawsuit allows a co-owner to compel the division or sale of jointly owned real property. Under Chapter 23 of the Texas Property Code, a partition lawsuit ensures that no co-owner is permanently locked into an unwanted ownership arrangement, but how the property is ultimately divided depends on the circumstances. A Texas partition lawsuit generally involves two phases. First, the court determines whether the property should be physically divided, known as a partition in kind, or whether it should be sold, known as a partition by sale. The second phase involves accounting, where the court determines each party's portion of the property or share of the proceeds. A partition in kind physically divides the property into separate individually owned parcels. For example, if two people jointly own 20 acres of rural land, a court might divide the property into two 10-acre parcels, as long as that division is equitable and feasible. Texas courts favor partition in kind when the property can be divided without materially impairing its value. This tends to be most practical for rural or undeveloped land where a clean geographic split is possible. But with a single-family home, commercial building, small urban lot, or condominium, physically dividing the property may be impossible or could significantly diminish its value. That's where a partition by sale may come into play. When physical division isn't feasible, or dividing the property would substantially harm its value, the court may order the entire property to be sold. The proceeds are then distributed among the co-owners according to their ownership interests. While every case is different, most Texas partition lawsuits follow a recognizable process. It begins when a co-owner files a petition in the appropriate district court under Chapter 23. The court then determines each party's ownership percentage. This can involve reviewing deeds, title records, and any existing agreements between the co-owners. If a partition in kind is being considered, the court may appoint commissioners to determine whether a fair physical division of the property is possible. If dividing the property proves impractical, the court can proceed toward an order of sale. Another important part of a partition case is the accounting phase. Texas partition law allows co-owners to seek reimbursement credits for certain contributions made during the period of shared ownership. These can include mortgage payments, property taxes, insurance premiums, necessary repairs, and improvements that enhance the property's value. These financial adjustments can be just as consequential as the partition itself, which is why careful documentation can be so important when pursuing reimbursement claims. The key takeaway is that Texas Property Code Chapter 23 ensures that no co-owner is forced to remain a co-owner. Whether that means physically dividing the property through a partition in kind or forcing the sale of jointly owned property, Texas law provides a structured legal remedy when co-ownership becomes unsustainable. But partition lawsuits are rarely simple. They can involve complicated questions of title, valuation, reimbursement, and long-term financial exposure.